I'm delighted to introduce Anjel Burgess. She has a master's degree in gerontology and a pre-medicine background. And as an attorney, Anjel brings a unique understanding to the practice of disability law. Cases often hinge on the ability to explain the evidence in a way that demonstrates a client's eligibility for benefits. And Anjel excels at this in all stages of disability proceedings through the Social Security Administration. She knows how to illustrate a condition revealed by medical evidence that impacts people's daily lives and to ensure that her clients' stories are told effectively so they can receive the benefits they need to move forward with their lives. Her skills, knowledge, and experience put her in frequent demand as a speaker with organizations and in the legal and medical fields. She serves on the board of directors for national, regional, and local nonprofit services, including the Hypersomnia Foundation, of course, Plan of Georgia, Special Needs Cobb and Clubhouse in Atlanta. And in order to help educate the public about resources available to those living with disabilities, Anjel even created a podcast. It's called the DisabiliTEA. The last bit is spelt TEA, in which she and her guests hold candid discussions about a variety of issues related to disability. When Anjel isn't helping clients address their needs or working to raise awareness of disability challenges, she enjoys spending time with her family and cheering on her favourite sports team. Thank you, Anjel, for joining us today. Just as a quick reminder to our audience, put your questions in the Q&A. Thank you.
Thank you, Claire. And thank you, everyone, for joining me today. Special thank you to the Hypersomnia Foundation for having me. So today we are going to talk about disability and IH. And before we get started, I just want to say we're going to talk about a lot of information. And if at any point you all have questions that may not be answered from the chat today, please feel free to reach out to me directly. So as an attorney, I have to first give you all a disclaimer. This presentation is for informational purposes only. I am in private practice. My job as an attorney is to help families with disability to get benefits from the Social Security Administration. I do not work for the Social Security Administration. Therefore, the views expressed today are my own. So let's get started about disability. What does it mean to be disabled? Now, the Social Security Administration has a definition, which you see on your screen, which is the inability to engage in substantial gainful activity by reason of any physical or mental impairments, which singly or in combination can be expected to result in death, or which has lasted or is expected to last for at least 12 months. What that means is to be disabled means that you are unable to work full-time in any job due to conditions that you have and the symptoms that flow from those conditions that prevent your ability to work. Next slide, please. So there are two different disability programs. They are both under the umbrella of disability, but they're very different programs in that the benefits that come with each program and the requirements for each program is different. In order to be considered disabled, however, the definition is the same no matter which program you may be entitled to for benefits. So the two programs are SSI, which stands for Supplemental Security Income, and SSDI, which is Social Security Disability Insurance. So these two programs are often confused, but they are quite different. SSI is a needs-based program, and it is typically for individuals who do not have the work credits or work history to qualify for SSDI. SSDI, on the other hand, is a workers program. So the benefits available from this program as an insurance program are available primarily to individuals who have worked and they have paid into the system. So let's talk about each one of these individually. With SSI, the needs-based program, this is more of your safety net. You have to meet certain financial requirements to be eligible for SSI. So, for example, if you are single, you cannot have more than $2,000 in income or assets in any given month in order to be eligible for SSI. If you are married, that amount goes up to $3,000 in income or assets. So they're very particular to make sure that you fall within those financial guidelines. SSI also comes with I call it a fixed payment amount because everybody starts at the same place. And this amount does go up a little bit each year, but currently the amount is $967. And so everybody kind of starts at that 967, and then depending on your particular circumstances, where you live, are you paying rent? Do you have other sources of income? That SSI amount may decrease. SSI also, and very importantly, comes with Medicaid health insurance. And this is insurance that you are entitled to as soon as you're entitled to receive SSI benefits. So it does provide you access immediately once you're eligible. SSDI, on the other hand, as I stated previously, is an insurance program. So this program doesn't care about how much money you have in income or assets. The concern with this program is, have you worked enough and paid into Social Security disability? The payments into this program are made through your FICA taxes. And so what happens is, if you are an employee, you are paying FICA taxes, not by choice, but it is mandatory as an employee. You're paying FICA taxes, and part of the money that you're paying for those FICA taxes goes to fund retirement, part goes to fund disability, and part goes to fund driver's benefits. So you are paying into this program as you work. And typically, if you've worked 5 out of the last 10 years, then you may be eligible to receive disability benefits. Now, the amount that you receive with SSDI, it's going to vary from person to person. And that's going to vary based on how much you've paid into the system. So a higher wage earner is going to have a higher SSDI benefit amount than a lower wage earner. The maximum for 2025 is $4,018 per month. With SSDI benefits comes Medicare health insurance, which is the health insurance that you would typically get at age 65. So if you are disabled and you're receiving benefits under SSDI, you will be eligible for Medicare insurance. Now, another difference from SSDI and SSI is that SSI gives you healthcare insurance immediately. SSDI, on the other hand, you have to wait 29 months from the time that Social Security says your disability began before you can get that Medicare health insurance. So that's problematic for a lot of people, because they have to figure out what they do in the meantime until they're eligible to receive health insurance under Medicare. But you will get your monthly payment each month. Next slide, please. So when you apply for disability, there is a process that happens with each application. The common kind of thought with Social Security disability is that applications are just rubber stamped. Like, the application comes in, and for some of them, they just say, oh, we're going to deny this. And there's actually quite an extensive process involved in evaluating claims. The first thing that you do, of course, is you file an application. After you file that application, there is an initial review that's done to see, are you eligible for the program that you've applied to? So if you apply for SSI only, then there's going to be an initial review of the information in your application to see, do you have more than $2,000 in income or assets if you're single? Do you have more than $3,000 in income and assets if you're married? And if you do, then you're going to get a denial. And they call that a technical denial because they can't continue the analysis any further because you don't meet the basic requirements for SSI. They haven't even looked at your medical, and they won't because you don't qualify for that program. Similarly, if you apply for SSDI only and you don't have enough work credits, if you haven't paid into the system long enough, then you too may get a technical denial because you're not eligible to receive those benefits. So they can't look at your medical if you don't meet the basic requirements for SSDI. So after they do that initial review and they determine, yes, they meet the eligibility requirements for whichever program they've applied to, and you can apply for both programs, then what happens is your file goes to DDS, which is Disability Determination Services. So every state has a DDS. And the rules are the same. So no matter if you live in Georgia or California, the rules for disability are the same. DDS does a file review. This is when they take a look at your medical and any other evidence to determine whether you meet the requirements for disability. Next slide, please. At DDS, they have essentially, I like to call it a team. And this team is involved with the processing and evaluation of each claim that comes to DDS. So this team typically consists of an adjudicator, a physician and/or psychologist, depending on what your impairments are, and a vocational consultant. So the team is responsible for the evaluation of your claim. The adjudicator leads the team. And the adjudicator is responsible for making sure that, they've requested the medical records for the providers that you've indicated, that they have all the forms that you needed to submit in order for your claim to be processed. And then that information is going to go over to the physician and or the psychologist who works for Social Security Administration, and they will do a records review of the evidence. So they will go through the medical records and give their opinions as to what they think your limitations are. With this review, they do not talk to you. They are only reading the medical evidence and the other evidence that you may have that might be vocational, might be educational, but they are only reading the evidence. And there are many instances where after a review of the evidence, they may think it would be helpful to have you actually examined by someone. And so that is the optional consultative examination. This is an examination that Social Security pays for, but they are sending you out to meet with either a physician or a psychologist who does not work for Social Security, so they are independent contractors. However, they are paid by Social Security. And this individual have a physical exam that in order, this will conduct the physical exam. If you have a mental health, conduct a mental health evaluation, and then they will send their report back to Social Security. And then a decision will be made on your claim. Now, typically at this level, which is the initial level, approximately 25 to 33% of the people that get approved for disability are approved at this level. So if they look at all of the people that got approved, 25 to 33% were approved at initial. And the timeline to get a decision at initial can be anywhere from 10 to over 14 months. And this is because the administration is still trying to recover from the impact of COVID and the impact that it had on, not only employees, but these independent examiners, and just a lot of things, unfortunately, with COVID slowed down the process. So it can be long to get a decision at the initial stage, but the administration is working on, shortening those wait times. So let's say that you get denied at initial. The next slide, please. Thank you. And let me just say that this slide here is about the 5-step sequential analysis that has to be performed in each case by someone at DDS. So Social Security, when they're looking at your individual file, they have to follow this analysis to see whether you meet the requirements for disability. And the first question that they ask is, are you working? If you are working, how much money are you making? Social Security considers substantial gainful activity for 2025 to be $1,620 per month gross. So if you apply for disability and you're making more than $1,620 per month gross, whether that's full-time or part-time work, then you can reasonably expect that your claim is going to be denied because you are engaging in substantial gainful activity. And so that would be the end of your case right there. You would get a denial letter from Social Security. They're not going to move any further if you are engaging in substantial gainful activity. If you are not, or you're not working at all, then they move to the next step of that 5-step analysis to determine whether you have a severe impairment that they believe will last a year or more. If they feel that you do not, then the determination or the analysis ends there. If they determine that you do have a severe impairment that's expected to last or has lasted for at least a year, then they move on to the next step. And so that's the way that it works with the 5-step sequential analysis. They are going through each step to determine whether or not you meet the requirements. Next slide, please. So if you have been denied at initial, the next step for you is to file an appeal. You have 60 days to file an appeal from the date that Social Security has denied your claim. If you do not file an appeal, then that decision stands and you cannot continue with the process. You would have to start all over in most cases if you decided to reapply later. But assuming that you have timely filed your appeal, that is called requesting reconsideration. And at reconsideration, your claim is back at DDS, where they are really doing an updated review of the medical evidence. So they've already denied you once. They've already reviewed the medical evidence and determined that you don't meet the requirements for disability. So at reconsideration, they're really looking to see, has anything new happened? Has there been a new diagnosis? Is there anything that has changed that would now make you eligible for benefits when you weren't maybe just a couple of months ago? You have that same team that is responsible for reviewing the claim, not necessarily the same players, but it's composed of the same people. So the adjudicator, the in-house physician and or psychologist, and the vocational consultant. Again, at this step, Social Security can decide if they hadn't previously to send you out for an exam, or in some circumstances, they've already sent you out previously and they decide, you know what, we need to send them out again, which again, Social Security will pay for, and that's perfectly fine. At reconsideration, as you might imagine, your chances of being approved are much smaller because they've already denied you once. So statistically, the people that get approved at reconsideration is about 10%. So that's 10% out of all the people that are approved for disability will get approved at reconsideration. Normally, it takes less time for that reconsideration decision. But again, because of the COVID delays in some states, it can take as long as it took for the initial decision or longer. So the timeline there, 6 to 14 plus months to get a decision at reconsideration. Next slide, please. So let's say that you are denied at reconsideration. You again have 60 days to file that appeal. If you do not file the appeal, that decision is the final determination and you're just not disabled. But if you do timely file the appeal, at this next step, you are requesting a hearing in front of an administrative law judge. Now, the administrative law judge stage of the process is typically the most favorable stage of the process. So if we look at all of the people who were approved for disability benefits, 55 to 60% of those people had to go all the way through the process. Initial, get denied, reconsideration, get denied, and then see an administrative law judge. And that is when most people are typically approved for disability benefits. You may ask why. What's the difference between the administrative law judge level and the earlier levels? The biggest difference is that there is a brand new review of the evidence. So the administrative law judge was not a party, had no knowledge of anything that happened at those earlier levels. So they are coming into your case at a later point, but they get to look and see what happened earlier. So they get to make a brand new decision. They are not bound to approve you or deny you, but they get to make a brand new decision based off of the evidence. Also, when you see an administrative law judge, a benefit is that you get to talk. So you get a chance to explain what your symptoms are, what your typical day is like, why you're not able to work, those types of things. And also the judge can ask you questions. If you have an attorney, your attorney will help develop the case and the evidence and ask you questions and help you to just point out things that the judge may not otherwise know. There is also a vocational expert that is a party to these hearings, and the vocational expert is going to testify about your job history, and they're going to testify about more practical things like, what do employers tolerate? Does an employer tolerate somebody who, falls asleep on the job 4 or 5 times during an 8-hour period? Well, no, an employer is not going to tolerate that. So a vocational expert will testify from the perspective of what employers tolerate to help the administrative law judge to determine whether or not you're disabled. The timeline to get a hearing is 6 plus months. 6 to 12 plus months is typically the timeline that you will see to get a hearing. So you've already waited for the initial decision, you waited for the reconsideration decision, and now you're waiting for the hearing decision. For a lot of people, that can be an over 2-year long period to get to the administrative law judge. Sometimes 3, sometimes 4. It just depends on how long it's taken at those earlier levels to get through the process. Next slide, please. So you may ask, okay, how does Social Security evaluate IH? You can back up one, please. And you'll see that it's blank below the caption there. And that's because the Social Security Administration has no guidance on IH, which is unfortunate. But I do believe that in the future that there could be some guidance for Social Security employees and judges on evaluating IH. Next slide, please. Social Security has an evaluation of narcolepsy, which is good. However, this evaluation was done back in 2016. So it's been 9 years since this evaluation was done. And as we all know, the definition of narcolepsy has changed. But the initial evaluation back in 2016, characterized narcolepsy as a chronic neurological disorder that was characterized by recurrent periods of an irresistible urge to sleep, accompanied by 3 accessory events. So basically, back in 2016, Social Security said, when we're looking at narcolepsy cases, we are expecting that there are 3 accessory events. There's cataplexy, there are hypnagogic hallucinations, and sleep paralysis. Next slide, please. We now know that that's not exactly the case. So what Social Security said back in 2016, you'll see on the left side of this slide, they noted that cataplexy was observed in 70% of all cases. Once awakened, the narcoleptic patient is alert. We now know that there are actually 2 types of narcolepsy, NT1 and NT2. NT2 does not involve cataplexy in most cases. So you can see that, while it's a good thing that there is some guidance, it takes a long time, number one, to get guidance on particular impairments, and then they're not updated very regularly. So this is where having a supportive doctor that can perhaps write a letter to explain, my patient has IH. This is how I know that my patient has IH. This is what IH is. That can be very helpful in helping a judge to kind of understand what's going on. And if you do have narcolepsy, then obviously we don't want a judge or anyone at Social Security to look at the old 2016 definition and say, well, this person doesn't have narcolepsy because they don't have cataplexy, when that's not necessarily the case. Next slide, please. So how do you prove the severity of a condition that Social Security seemingly knows nothing about, or at least they don't have any guidance about how to evaluate the case? So it's important that if there's a diagnosis of IH, there's documented support for the diagnosis. It's not uncommon to see in medical records notations of hypersomnia. Now, that doesn't mean that somebody has IH. And they may not have IH, right? But there could be hypersomnia due to medication, due to multiple causes. So it's important that with IH, there is some documented support for the diagnosis. And of course, you're going to find that information in the medical records. If possible, were other disorders ruled out? As many of you know, the path to an IH diagnosis is usually many years long. And so what typically happens is you can see the progression from, this person has depression to, we don't know what's going on with this person, to sometimes, years later, this person has IH. So it's important that there is at least some rule out of other disorders to support that diagnosis of IH, if possible. If you've had sleep studies and MSLT, PSG, it's important to also have that information in the medical records, and preferably, some indication of how those results support the diagnosis. I know that they don't always support the diagnosis, but if they do, it's important to note that. What's really also important in your medical records is that there is information about what kind of treatment you're receiving. And oftentimes you've tried many different medications, and there may have been some adverse side effects. There may have just been medications that didn't help at all, but it's important that that's documented, because Social Security wants to see that you have tried treatment or that you are still receiving treatment, but that treatment is not sufficient or helpful enough to allow you to work on a full-time basis or at substantially gainful levels. If there are side effects, you want to make sure that you're communicating with your health professionals. These are the side effects that I'm having from the medications, because sometimes what I see is that no are effective. And if that's explain why you may not be taking medications right now, or you may be taking an off-label medication right now. It's important that the medical records kind of tell that story. And as I previously stated, if your physician or health professional is supportive, that can make all the difference in proving the severity of the IH. And they can show their support by writing a letter, by filling out forms, just to explain in more detail, because your doctor knows about IH better than anybody. And, you know, judges are lawyers, so they're not your doctor. So it can be helpful to explain to them from a medical perspective what the condition is and how it impacts you in particular. Next slide, please. Now, the other and probably more important question is, how do you prove that you're unable to work? So let's say you've got the medical records. The medical records are showing you have IH, that you've tried all these medications. How do you prove that you're not able to work? Well, one way is the medical records themselves. If you are able to keep a diary or a sleep log, or just, you know, anything to help when you go to the doctor's office for you to be able to report, this is what my day looks like. You know, I may sleep for 16 hours a day, or I may have days where, you know, I take three 3-hour naps, and I'm able to be productive for 3 hours. Whatever the case may be, it's important that in your medical records, there is some indication of how you are impacted and what you have to do to kind of get through a typical day if you're able to. Other ways that you can prove that you're unable to work is if you have any sort of disciplinary records or warnings from work, you had performance evaluations that perhaps showed a decline in functioning, attendance records that show absenteeism, that show showing up late for work or having to leave early. Any emails that you may have with your supervisor who says, Anjel, I noticed that, you know, you've been falling asleep at your desk. You know, what's going on? Let's talk about this. What can we do? Those emails can be helpful to prove that you are unable to sustain work. Also, if you have been terminated, sometimes separation notices will say things like, you know, excessive absenteeism, not able to complete the duties of the job. Any of those things can be evidence to prove that you're unable to work. If you are a student, or you are someone that is kind of new to the workforce and you've been to vocational rehabilitation and they've tried to help you find a job, they will do work readiness assessments, and they may do an assessment that shows that you're not able to stay focused and that you fall asleep on the job, or that you are just not able to complete tasks. And that can be helpful to show that you're unable to work. If you're in school and you've got a 504 plan or teacher evaluations, disciplinary reports, anything like that can also be helpful to prove that you're unable to work. And the biggest way that can help you to prove this, of course, is to hire an attorney. Next slide, please. So you don't have to hire an attorney to prove your case. However, if you don't know what Social Security's rules and regulations are, how you prove disability, it's in your best interest to hire an attorney who knows the process, who understands what your limitations are so that they can help present the evidence in the most effective way. So Social Security attorneys are different than your typical attorney. We are regulated by the Social Security Administration. So we have to be approved to represent you. They also set the fee. And so what Social Security says is that in order for your attorney to get paid, they have to, number one, win your case for you. And number two, they have to get you back pay. So earlier we talked about how long the process can be. If Social Security ultimately decides that you're disabled, the likelihood is that they didn't do that within 4 or 5 months. It was probably a much longer process. So they are going to owe you back pay, which is also known as past due benefits. If you have an attorney, that attorney is paid out of your back pay, and Social Security sets that amount at 25% of your back pay with a cap of $9,200. And that cap is supposed to go up each year, consistent with the cost of living adjustment, but I don't have any indication at this point as to it going up yet for 2026. Social Security will pay the attorney's fees directly to the attorney. So when they're figuring out how much your back pay is, they are going to put the attorney's fees to the side, and then they will pay the attorney directly. At this point, I am ready and available to take any questions.
Thank you, Anjel. That was so informative. There's a lot in there, I know, as people kind of process that. You can drop your questions in the Q&A. We do have a question, so if it's okay, Anjel, I will read that to you.
Sure.
From an anonymous attendee, they're asking, what if there is an inconclusive MSLT, that's a multiple sleep latency test, but IH positive from actigraphy results? What then?
So at that point, remember your health professional, whether that's your doctor, whether that is a nurse practitioner, whomever it may be, it would be really helpful if they wrote a letter or filled out a form that is submitted to Social Security where they can indicate, this is how I know that this person has IH, or this is why I believe that this person has IH. And it may very well be that, okay, the MSLT is not positive from that regard, but if your medical professional believes that any other diagnostic test supports that diagnosis, then they will just indicate that. Or in their medical records, they can indicate it there. You know, it may say MSLT is not showing IH, but I believe patient has IH based off of X.
Awesome. Okay, thank you. All right, I have a question. Actually, it's offline, but the question is, what advice would you give to someone who is just beginning the disability application process for IH right at the beginning?
Right at the beginning, I would say that it can be really helpful if you are still working. This is my ideal situation for my client. I would like for my client to still be working and be making plans to hopefully go out on short-term disability, followed by long-term disability or FMLA, but preferably you've got a disability plan available through your employer. And as soon as you go out of work and you apply for short-term disability or long-term disability, as soon as you go out of work, you also apply for Social Security disability. That way you have some income coming in while you're going through that process. If you were not able to do that and you are just in the early stages of applying and you know you aren't getting any other source of income, the advice that I would give would be to talk to your doctor, explain to your doctor why you're not able to work, and ask for their support. You know, your doctor is probably trying different treatment methods, and if they're not working and you're communicating that, most times they are more than happy to support you. If you have your doctor's support, that will help explain to Social Security, you know, the severity of IH when most people don't know what IH is.
Yeah. Thank you. That's super helpful. Okay, we have another question, which says, what about accommodations at work if you don't qualify for disability? For example, being able to use a room for a quick nap when needed, or WFH on days you are too tired to safely drive.
I think that's great. I think that before you go out of work, you know, if you can help it, accommodations can be another way to keep you employed for as long as possible. So I would recommend that. I would recommend, instead of, you know, resigning from your position, try to see if you can get some accommodations. There are employment attorneys that will help to make sure, depending on the size of your employer, that they are following the rules as it relates to accommodations. So that is a great first step before you think about, I'm going to have to leave this job.
Okay. Thank you. There's actually a lot more questions. I'm not sure we have time for all of them, but let's see what we can do. All right. So next question. I had a hearing level meeting back in 2014 and was shown to not be able to work even by the vocational representative. After I left that meeting, I was denied Social Security. Am I able to fight this? It was over 10 years ago, but I just haven't physically been able to do anything until this point.
Okay. So at the hearing, you know, I talked about the vocational expert being a party to the hearing. The vocational expert, though, is not a decision maker. And so even though that individual may have testified that, you know, a person with these limitations could not work, the administrative law judge can determine that you have different limitations and that those limitations would result in you being able to work. So ultimately, despite what the vocational expert's testimony is, the assignment of limitations rests solely with the administrative law judge.
Okay.
With a denial from a hearing, you only get 60 days to to appeal. So unfortunately, you would not be able to do anything about that 2014 denial. What you could explore is potential opportunity to reapply either for SSI or SSDI if you have sufficient quarters. If you've worked since then, even part-time, maybe you have sufficient quarters to reapply for SSDI.
Thank you. Okay, next question. At what point would you recommend a person with IH or narcolepsy, in parentheses, should remove their application form for consideration? I'm asking for a friend who's been told they will owe money or lose other benefits if they continue.
Okay, so that, I think I would need a lot more information to kind of understand the context of that question. So I would ask that that person reach out to me directly and we can talk about the specifics.
Okay, awesome. Yeah, I think, I mean, normally we sort of, in these contexts, ask, you know, that questions are quite generic, but I think because of the nature of your work and people's situation, they are going to be a little bit more specific and personal.
Yes.
And again, thank you for that incredibly informative presentation. We are a little bit out of time, so I'm going to ask those that also added the questions in the Q&A to actually reach out to you, and we can provide those details, as I know you did give them at the beginning. But I'd love to thank you, Anjel, for giving up your time today and for being a wonderful board member with the Hypersomnia Foundation and a true asset and encourager for our community over many years, actually. So thank you again, and we hope you have a good rest of your
Thank
day.
you.
Bye for
You all
now.
do the same.
Thank you.